right, this is the second attempt to get this started. Hey! We are live on YouTube. Okay. I just have to delete that one. Sorry, folks. This is not the intro I was planning on. I had a scheduled stream. I started and it never got out to the platforms. So I had to start over. But now it seems we are actually. All right, here we go. Checking the chat. Checking the chat. Okay, checking Rumble. Dun, dun, dun. Let's see. Yeah, all right. We seem to be live on Rumble as well. I don't know why this was screwed up. But hey, now we're live at least. Now we are live. Yeah, all right. Let's start. All right, let's start over. Welcome to the show. It is Monday. It is in the middle of the night here. And so this is kind of last minute. About an hour ago, there was a huge document dump in the United States of America versus Matthew Farwell, the Sandra Birchmore case. And amongst other things is the government's response to different motion in limines from the defense. The motion in limine, the response for Dr. Michael Baden, which was what I thought the last one was, but now it's finally here. They also have the defense wanting to throw out testimony regarding Sandra's cause of death. The U.S. opposition to Farwell's request to exclude testimony concerning grooming. Motion in limine, excluding complex DNA mixture evidence. There's a huge, enormous documents dump. But as of now, I have time for one of them. And I chose the government's opposition to defendants rule 702 motion in limine to exclude the expert testimony of Dr. Michael Baden. Because this is the huge one, in my opinion, because Dr. Michael Baden is the one who determined that Sandra Birchmore did not end herself. It was, in fact, a homicide. All right, welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Oh, raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus. Santa Claus.
I don't know why Rumble Studios have my intro. Play once, done. Rumble Studios, this is a glitch of yours that for some fucked up reason you have it on repeat. Stop that immediately. All right, sorry. Also, when I did the thumbnail for this stream, I did it for against the Farwell's motion in limine regarding the search warrants, where Farwell's where the state or the government the United States of America wants to present the warrants in trial to show the difference in the corrupt and botched state investigation compared to the federal investigation. But since then, I saw that there was also filed an opposition regarding Farwell's motion in limine of Dr. Michael Baden. So, yeah, that's the one. So, after the show, I have to change the I have to change the thumbnail. But hey, stuff happens. Hello, folks. Hello, folks. Thank you for being here at this unusual hour for me to stream. But I just wanted. I wanted. So, folks, here it is. This is the one I've been waiting for. U.S. District Court, District of Massachusetts, government's opposition to Defendants Rule 702 motion in limine to exclude the expert testimony of Dr. Michael Baden, MD. Now, I did a stream regarding Farwell's motion to exclude Dr. Michael Baden. It was about a week and a half ago. So if you want the context of this motion, this opposition, after the show, go watch that one. And hello, folks over at Rumble. Hello, folks over at YouTube. Yeah, let's go. Government opposition. Yeah. The United States of America by Leah B. Foley, U.S. attorneys, and Brian A. Fogarty, Elizabeth Riley, Tori Cummings, opposes defendants Matthew Farwell's motion in limine to exclude the expert testimony of Dr. Michael Baden. Farwell moves to exclude Dr. Baden's testimony under Federal Rule of Evidence 702, arguing that his methodology and its application in this case are unreliable because, according to Farwell, medical literature indicates that certain injuries Sandra Birchmore suffered could also be consistent with ending by self-ending. And Dr. Baden did not review particular pieces of evidence, and Dr. Baden's assessment regarding the significance of Birchmore's hair being tangled in the ligature, and his conclusion that because Birchmore did not die by self-ending, the scene was staged, are both the product of analytical gaps. Farwell's arguments are without merit. Introduction. As a threshold matter, the government has noticed two expert witnesses to testify regarding Birchmore's injuries and the cause and manner of her demise. Dr. William Schmock, MD, and Dr. Baden. Dr. Schmock is an emergency medicine physician with nearly 40 years of experience regarding the examination and investigation of injuries in living and deceased patients. Particularly relevant to this case, Dr. Schmock is a leading authority on asphyxia-related deaths, including manual and ligature strangulation. Dr. Baden is a forensic pathologist who has served as, among other things, the chief medical examiner for New York City and director of the New York State Police Medico-Legal Investigations Unit. If both witnesses were called to testify at trial, they would cover much of the same ground, with Dr. Schmock diving deeper into topics that are especially relevant in this case. Therefore, to avoid presenting cumulative evidence, the government does not intend to call both experts. Instead, the current plan is to introduce Dr. Schmock's testimony, reserving Dr. Baden for a rebuttal case if necessary. Oh, this is clever. This is clever. This is clever. Oh, what a move by the government. Oh, what a move. So they recall Dr. Schmock, who has hands-on experience of these types of endings. But if the defense, Mr. Farwell, puts on his own expert, which they will, depending on what that expert testifies to, then they will use Dr. Baden in a rebuttal case. That is very clever, because what they are doing here is having the guy, Dr. Schmock, who who the defense really can't say anything about regarding his expertise and anything. Also, kind of cripple their ability to use Dr. Baden's findings against Dr. Schmock. Because if they do, then they will invite themselves Dr. Baden. And in the off chance they don't, the government can still call Dr. Baden. Yeah. Hey, Lady Fang. Yeah, exactly. Not often we hear Nick praising the government in cases. No, I mean, it's rare. It's rare. But this is actually really clever. This is actually really clever. Again, Mr. Farwell is innocent until proven guilty in a court of law. My hope has always been that the state will have their own case. It won't have now under the direction of DA Michael Morrissey, because the only reason why anyone wouldn't want to prosecute Matthew Farwell with the enormous amount of evidence against him has to be because they like him. They want to protect him. You read in what you want in why the now administration under DA Morrissey keeps protecting PDF cops, groomer cops, Austrian painter fans cops, and so on and so on. In my opinion, you can only do that if you are of the same opinions as the people you protect. But we can still form our opinion regarding Matthew Farwell based on the evidence we see. But yeah, I must say, this is very, very clever. Okay, on the substance of Dr. Baden's opinion, Farwell purports to challenge Dr. Baden's methodology and his application of that methodology in this case. However, the gist of Farwell's argument for excluding Dr. Baden's testimony is that Farwell has cherry-picked aspects of medical literature that purports to suggest that the injuries Dr. Baden notes could also be consistent with the conclusion that Birchmore died by self-ending. Farwell takes Dr. Baden's observation in isolation, cites portions of medical literature that he claims suggest the injuries could be consistent with self-ending, and concludes that Dr. Baden's reasoning is flawed. Farwell's argument for unavailing for several reasons. It fails to account for the fact that Dr. Baden's opinion does not rest on isolated observations. See this case. Holding the district court erred in reasoning that because no one piece of evidence in isolation support the proffered conclusion, a conclusion based on the totality of the evidence was unreliable, citing Notre Suite case from 2000. Holding that an expert's reliance on individual pieces of evidence, insufficient in themselves to prove a point, did not render his opinion speculative. Nor do the sources Farwell cite exclude the possibility that the observed injuries are the result of a homicide. And, as the First Circus has held, these sorts of challenges to the underpinnings of Dr. Baden's opinions are quintessential cross-examination, not a basis to prevent the jury from hearing the testimony. That was my exact argument in the prior video when I read from Farwell's motion to exclude Dr. Baden. That the arguments they made is 1, cross-examination, and 2, present your own expert. Battle of the experts. And it's, well, the government seems to be of the same opinion. Farwell also alleges that Dr. Baden's opinion is based on erroneous and insufficient facts. Not so. Dr. Baden has undertaken an analysis of the observed physical and medical injuries that Birchmore suffered. From those observations and related evidence, he has opined, as a forensic pathologist would, about the cause and manner of death. In 2024, he took into account the possibility that Birchmore died by self-ending. Indeed, that is what the Office of the Chief Medical Examiner had written in the autopsy report, and the MSP has publicly concluded at the time. Yeah, so he took that into consideration. Moreover, Farwell fails to explain why the absence of DNA results undermines Dr. Baden's conclusion based on the evidence he reviewed. Dr. Baden's opinions do not suffer from analytical gaps. Farwell contends that Dr. Baden has no basis to testify regarding the significance of the fact that Birchmore's hair was entangled with the ligature, or the conclusion that Birchmore's body was staged. However, Farwell fails to account for the fact that Dr. Baden's opinion rests on more than 50 years of experience as a forensic pathologist, including his experience examining women who had died by self-ending by the neck. Farwell also fails to acknowledge that as a matter of logic, Dr. Baden can infer that the scene that purports to show Birchmore in self-ending by neck position was staged, because the evidence strongly supports the conclusion that Birchmore died in a different way, by homicidal asphyxia and strangulation. And they are citing US versus Mooney and Rees-Trosh versus Pepsi. Background. Dr. Baden's professional experience. Dr. Baden is a board-certified forensic pathologist. He worked as a medical examiner in the Office of the Chief Medical Examiner for New York City from 1961 to 1985, and served as the Chief Medical Examiner from 78 to 79. From 1985 to 2011, Dr. Baden served as the Director of the New York State Police Medico-Legal Investigation Unit, which is a specialized unit that provides consultant services in death investigations. Dr. Baden worked as a medical examiner for 50 years and performed more than 20,000 autopsies. In addition to this extensive practical experience, he has held professional teaching appointments at Albert Einstein Medical School, Albany Medical College, New York University School of Medicine, New York Law School, and John Jay College of Criminal Justice. He has consulted for the FBI, Department of Veterans Affairs, ATF, DEA, and U.S. Department of Justice. Dr. Baden also testified as an expert in federal and state court and authored numerous publications in the field. And there is a CV attached as exhibit. Dr. Baden's role in the investigation. In 2024, attorneys representing Birchmore's next of kin engaged Dr. Baden to evaluate the evidence regarding Birchmore's death. As part of that evaluation, Dr. Baden reviewed the autopsy and toxicology reports, crime scene and autopsy photos, autopsy x-rays, and the Stoughton police report of the internal the Stoughton police report of the internal affairs investigation conducted following Birchmore's death. Yeah, that is the one that Chief McNamara ordered. Because Chief McNamara, quite soon after Birchmore's ending, she saw foul play. And if you want to know more about the fight that Chief McNamara is in now, I have videos on that as well, where the town of Stoughton and their town manager tries to have her fired. Why? Because she cooperates with the feds regarding the Sandra Birchmore investigation. And she has, this we are talking about now is her first report of the Internal Affairs investigation. She has since conducted a second. She was ordered by the town manager of Stoughton to delete that report. Interesting to know is that the town manager of Stoughton and DA Michael Morrissey used to work together. Yeah. Isn't it strange that everything boils back to DA Morrissey and his wants and wishes to protect PDF cops, groomer cops, murderers cops? Isn't that strange? And that autopsy report indicated that Birchmore died by self-ending. And here's a footnote: the facts of the case have been briefed extensively, and a full description of the crimes and investigation are included in the government's trial brief. Yay! Dr. Baden's expert testimony. At trial, the government could call Dr. Baden to testify regarding the following topics. A. The autopsy process. Dr. Baden can testify about the process of conducting an autopsy. He can explain the steps taken in cases of suspected asphyxia deaths and the factors to consider in determining the cause and manner of death. Yeah, I would imagine so. Dr. Baden, okay, B. Birchmore's injuries and other evidence. Dr. Baden can testify regarding the injuries that Birchmore sustained. Specifically, Dr. Baden can testify that based on the injuries he observed in the material, Birchmore would have lost consciousness in less than 10 seconds and died within a few minutes. Dr. Baden can testify that Birchmore presented at autopsy with petechial hemorrhages in her eyes, as well as hemorrhage of the left sternothyroid muscle and a fracture of her right hyoid bone. Dr. Baden's opinion is that all of the pathologic findings are commonly found in homicidal strangulation, both manual and with use of a ligature. Yeah, remember the ligature? That is the strap that she had around her neck and then around the doorknob. That had Farwell's DNA on it. Furthermore, Dr. Baden can testify that based on his 50 years of experience and according to his review of the medical literature, the foregoing injuries are not commonly present in self-ending. He will explain that in his experience and through his research, fracture of the hyoid bone is very uncommon in self-endings, especially in partially suspended hangings, such as the position in which Birchmore's body was found. Dr. Baden will cite the fact that Birchmore's hair was tangled with the ligature as inconsistent with his experience with self-endings. He will also explain that the ligature tightly applied and crossing Birchmore's mid-neck horizontally would have compressed the carotid arteries bilaterally. The appearance and location of the ligature was also, in Dr. Baden's opinion, consistent with homicidal strangulation rather than self-ending. Cause and manner of Birchmore's death. Dr. Baden can testify that his opinion is that Birchmore's cause of death was asphyxia and strangulation, and that her manner of death was homicide. And then they go through the legal standard. Under Rule 702, expert testimony is admissible if the proponent shows by a preponderance of the evidence that the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B. The testimony is based on sufficient facts or data. C. The testimony is product of reliable principles and methods. And D. The expert's opinion reflects a reliable application of the principles and methods to the facts of the case. And then they go into Daubert. Let's see here. 2. The court should admit testimony that is based on sufficient facts or data, which is the product of reliable principle and methods. Courts may exclude expert opinions that are, quote, connected to existing data only by the ipse dixit of the expert, or opinions arising for too great analytical gap between the data and the opinion proffered. Quoting the Millward case, who is also then quoting another case. However, this does not mean that the trial courts are empowered to determine which of several competing scientific theories has the best provenance. Daubert does not require that the party who proffers expert testimony carry the burden to proving to the judge that the expert's assessment of the situation is correct. It demands only that the proponent of the evidence show that the expert's conclusion has been arrived in a scientifically sound and methodology. For fuck's sake, stop using big words. Methodologically reliable fashion. The object of Daubert is to make certain that an expert, whether basing testimony of professional studies or personal experience, employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. Yeah, and there's not a person on this planet except, Farwell's attorney. Now, I don't blame Farwell's attorneys for trying to exclude this. I really don't. I would call them out if they didn't try. But they really are grasping at straws. Because the case, based on the evidence that we've seen, is really, really strong. Really, really damn strong. And ultimately, the fact that another explanation might be right is not a sufficient basis for excluding the expert testimony. Exactly. Battle of the experts. Cross-examination. Any alleged flaws goes to the weight of the expert's opinion, not its admissibility. There is an important difference between what is unreliable support and what a trier of fact may conclude is insufficient support for an expert's conclusion. So this is just citing case law now. 4. Evidentiary hearing is not required. It is well settled that the court is not required to conduct an evidentiary hearing to determine the admissibility of expert testimony under Rule 702. See Crater statute. There is no particular procedure that the trial court is required to follow in executing its gatekeeping function, and we have specifically rejected the argument that the district court must necessarily hold an evidentiary hearing. Me personally, I would love this to go through a Daubert hearing, just to see Dr. Baden annihilate Farwell's arguments. Argument. The court should deny the motion to exclude Dr. Baden's expert testimony. The court should deny Farwell's motion to exclude Dr. Baden's testimony because his opinions regarding Birchmore's injuries and the cause and manner of her death are well supported by his extensive professional experience as a pathologist and medical examiner, as well as the medical literature. Dr. Baden's opinions are product of reliable principles and methods applied to the facts of this case. Farwell argues that the court must exclude Dr. Baden's testimony because Farwell offers a different interpretation of the medical literature's assessment of the prevalence of petechial hemorrhages, facial abrasions, and hyoid fractures in self-ending versus homicide. Farwell is wrong for 3 reasons. First, the court should reject this challenge because Farwell invites the court to do what the First Circuit has said it should not, which is to exclude testimony that is based on the confluence of multiple factors simply because the individual factors considered in isolation are subject to alternative explanations. Moreover, in service of this flawed argument, Farwell misquotes Dr. Baden's report. In an effort to challenge Dr. Baden's reliance on the existence of petechial hemorrhages as a piece of evidence of self-ending, Farwell misquotes Dr. Baden's report to suggest that Dr. Baden opined that petechial hemorrhages alone, quote, are commonly found in homicides, manual and ligature, but not in self-ending. Yeah, that is not what Dr. Baden said. Then Farwell goes on to quote a passage from Spitz and Fisher's medio-collegial investigation, which states over 50% of self-ending shows petechial hemorrhages. Farwell presents this as an example of Dr. Baden offering an opinion that is at odds with the literature he cites. The problem is Farwell uses incomplete excerpts of Dr. Baden's report, omitting the preceding sentences that reveal that it is the combination of several pathologic findings that are commonly found in strangulation, ... not in self-ending hangings. See Baden report at 2. What Farwell does not put before the court is the full passage from Dr. Baden, which is not inconsistent with the literature. This is also what I said in that video. There seems to be a lot missing. The ... means they have cut out a lot of information. So let's now see what it actually said. In context. The photographs show a very tightly applied ligature crossing the midneck horizontally that would have compressed the carotid arteries bilaterally and would have caused a loss of consciousness in less than 10 seconds and death within a few minutes. There were prominent petechial hemorrhages in the eyes and skin above the ligature, an abrasion on the chin, hemorrhages in neck muscle, and a fracture of the hyoid bone. All of these pathologic findings are commonly found in homicidal strangulation, manual and ligature, but not in self-ending hangings. Yeah, they removed that there were more in that passage. They removed a whole lot of text. That is borderline unethical. Borderline unethical. But I don't know. They must have known that the reply would contain the whole passage. See Baden report emphasis Ellen. And Farwell does the same thing, mistakenly attributing a conclusion about a confluence of evidence to its constituent parts in his attack on Dr. Baden's reference to the fractured hyoid bone. The bottom line is Dr. Baden's testimony does not rise or fall with any of the facts identified in his disclosure. Therefore, Farwell's attack on the individual parts is unavailing. Second, Farwell attacks various components of Dr. Baden's opinions by citing literature that he claims suggests the injuries in isolation could also be consistent with self-ending. Even putting aside that he misquotes Dr. Baden's report, he still overstates the degree to which the literature supports his argument. The literature he cites does not say that Dr. Baden's opinions about the cause and manner of death must be wrong. Rather, the literature, at best, for Farwell, says the isolated injuries could also be consistent with self-ending. For example, the literature indicates that petechial hemorrhages alone occur in more than 50% of self-endings. Importantly, that does not rule out their existence in homicidal strangulations. At trial, inherently, some matters that are just proper subject of expert testimony will be in dispute. Therefore, not surprisingly, it is well settled that alternative theories and interpretation of the evidence do not require excluding expert opinion testimony. It merely underscores the need for a jury to resolve the dispute after considering cross-examination and any additional expert testimony on the subject. Third, Farwell criticizes Dr. Baden for not explaining the absence of other evidence that Birchmore died by asphyxia and strangulation. Farwell cites the purported absence of defensive wounds and his claim that there is no hemorrhage at the site of the hyoid fracture. On the absence of defensive wounds, Dr. Baden does indeed cite evidence of resistance. Birchmore's hair entangled with the ligature, Dr. Baden provides the further explanation that the injury Birchmore sustained would have caused a loss of consciousness in less than 10 seconds. Yeah, and also we know through different motions regarding the text messages between Farwell and Sandra is that he liked to subject her to shock sex. And I said this in a prior video. She probably thought that was just one more of the times where he got off on strangling her. She became unconscious, thinking she would wake up again, while Farwell made sure she didn't. Allegedly. And Farwell's reference to the absence of a hemorrhage at the site of the hyoid fracture is a red herring. The medical examiner identified an acute perimortem fracture of Birchmore's hyoid bone at autopsy. By all accounts, this injury occurred at or around the time of Birchmore's death. Dr. Smock personally inspected the hyoid bone. And requested that high-resolution photographs and CT scans be taken of the hyoid bone. Remember last time we talked about this? Why was Dr. Smock there? Working for the government? Requesting pictures taken of the actual hyoid bone. All the way back in 2021, the feds was already in Norfolk County investigating shit. All the way back in 2021. The feds has been there, as it seems, for quite some time investigating the Norfolk County. That is what this indicates, in my opinion. Dr. Smock noted that there was a hemorrhage associated with the fracture. See here, footnote 3. While the medical examiner did not dissect the hyoid bone to determine whether it was at the fracture site, there is clear discoloration suggesting hemorrhage at the right greater horn of the hyoid bone. There you have it. He also requested that a forensic anthropologist examine the scans of the hyoid bone. That forensic anthropologist confirmed that Birchmore's hyoid bone had been unfused and that it had suffered a perimortem inward medial fracture at the right greater horn. Farwell suggests that because Dr. Christensen, a forensic anthropologist, did not note a hemorrhage at the hyoid bone, one must not exist. This is flawed. First, Dr. Christensen is a forensic anthropologist who critically evaluated the scans, but not the high-resolution photographs of the bone that Dr. Smock commissioned. Footnote 4. Farwell incorrectly states that Dr. Capo Martinez, rather than Dr. Smock, took these photographs. Oh, yeah, that's a problem. So the Farwell defense believed it was the medical examiner, the state's medical examiner, who took the photos. No, it was Dr. Smock, who was sent there by the feds, as it seems. Dr. Christensen performed a radiological review of the bone from a lab in Quantico after it had been shipped to her laboratory in Huntsville for imaging. So even though Sandra Birchmore was cremated and buried shortly after this, the feds kept evidence. Again, the feds have been in Norfolk County for quite some time. And this also tells us they were already in Norfolk before the Karen Reed case, investigating what seems to be corruption within the Norfolk DA's office, the Massachusetts State Police, and local law enforcement. Dr. Christensen did not review the 22 photographs of the bone before it was sent for imaging. A hemorrhage at the fracture site would not appear on the scans that Dr. Christensen critically evaluated, so an absence of a noting such fracture is not surprising. The defense expert, Dr. Andrew, makes only a passing reference to the existence or lack of hemorrhage associated with the fracture, stating that Dr. Smock's finding of hemorrhage associated with the bone fracture was an interpretive overreach, unsupported by the post-fixation photographic images of the bone. Dr. Andrew is notably silent on the medical examiner's observation of the hemorrhage of the left sternothyroid muscle, suggesting bilateral pressure on the neck. The presence of the acute hemorrhage of the left sternothyroid muscle, as noted by the medical examiner, is evidence that Birchmore was alive when she suffered this injury. Dr. Baden's opinions are based in fact. Farwell argues that Dr. Baden's opinions are based on erroneous or insufficient facts, because Dr. Baden did not review Birchmore's mental health records or the subsequently completed DNA test results. However, these items do not undermine Dr. Baden's opinions. The context of Dr. Baden's review reveals why Birchmore's mental health records do not affect the soundness of his opinion. When Dr. Baden was engaged by Birchmore's next of kin to evaluate the circumstances of her death, it was against the backdrop of the OCME's ruling and state police conclusion that Birchmore died by self-ending. Those were the facts as presented to Dr. Baden. No historical reference to self-ending ideations in the medical records could have provided a stronger bias in favor of a self-ending finding. Nevertheless, Dr. Baden, based on his evaluation of the physical and medical evidence, came to the opposite conclusion. Neither do the DNA test results undermine Dr. Baden's opinions. Dr. Baden's role was to examine evidence regarding the injuries to Birchmore and opine about their significance and the cause and manner of her death. The DNA evidence that Farwell cites does not change that fundamental analysis and conclusion. The absence of Farwell's DNA under Birchmore's fingernails does not make it less likely that she suffered the injuries Dr. Baden observed. Similarly, Farwell does not explain precisely how Dr. Baden's failure to discuss the existence of a mixture of likely Farwell DNA in Birchmore's underwear and the exclusion of Farwell as the biological father undermines Dr. Baden's opinions. Merely stating that Dr. Baden did not consider it does not demonstrate why he should have done so. Yeah, we now know that Farwell wasn't the father of the unborn child, but he thought he was. He thought he was. That is what matters. C. Dr. Baden's opinions contain no analytical gaps. Farwell identifies two aspects of Dr. Baden's testimony that he claims are unsupported and arise from analytical gaps. Dr. Baden's observations that Birchmore's hair was entangled with a ligature, which is consistent with resistance during homicidal strangulation, and that the ligature was tied to a doorknob to give the appearance of a self-ending. These observations and conclusions are well supported. To begin, Dr. Baden has participated in roughly 20,000 autopsies over 50 years. His extensive experience observing and examining persons who have died by self-ending provides a sufficient and unique basis from which to opine about the very specific fact regarding Birchmore's hair placement. Stop eating while you host a YouTube show. Absolutely disgusting. Do you know, Forrest, fuck off. I'm not eating. These here are nicotine pouches. And if you find it absolutely disgusting, fuck the fuck off, you retard. And off he fucked. There! Now he doesn't have to see it. Now he doesn't have to see it. There, easy. I made the decision for you. You're welcome. Here, forward to cites no medical literature on the subject, and other than concluding that Dr. Baden cannot rely on his experience alone, he fails to explain why such robust professional experience is insufficient. The court should also reject Farwell's attempt to exclude Dr. Baden's opinion that the ligature was tied around the doorknob to give the scene the appearance of a self-ending, because that conclusion is reasonable inference from his well-supported opinion that Birchmore died by homicide. If Birchmore was ended by strangulation, either manually or with a ligature, the ligature would not have been in the position depicted in the scene photos that Dr. Baden reviewed. Accordingly, Dr. Baden can testify that the ligature was moved to the doorknob, giving the scene the appearance of a self-ending. Citing the Mooney case, holding that an expert may testify regarding inferences from the evidence. D. The probative value of Dr. Baden's opinions far outweighs any risk of undue prejudice. Applying Rule 403's balancing test, the court should decline to exclude Dr. Baden's expert testimony. The cause and manner of Birchmore's death are critically important disputed facts in this case. Dr. Baden's testimony is based on half a century of relevant professional experience and review of physical and medical evidence in this case, notwithstanding Farwell's attempt to pick apart the basis for Dr. Baden's opinions. Dr. Baden's summary report and the government's disclosure demonstrate that he applied the requisite level of intellectual rigor in forming his opinions. Accordingly, his opinion reflects a reliable methodology applied to the facts, not merely a patina of science, and the court should hold that probative value is not substantially outweighed by danger of unfair prejudice or confusion. 2. The court should deny the motion to exclude Dr. Baden's expert testimony without conducting an evidentiary hearing. The court should deny Farwell's motion without conducting an evidentiary hearing. The First Circuit Court has repeatedly held that a trial court need not conduct an evidentiary hearing in order to fulfill its gatekeeping function. Here, Dr. Baden's report, the government's disclosure, and the parties' briefing provide a sufficient record from which the court can apply Daubert and rule that Dr. Baden's expert testimony is admissible. Conclusion. For the foregoing reasons, the government respectfully requests that the court deny defendant Matthew Farwell's motion to exclude the expert testimony of Dr. Michael Baden and rule that his testimony is admissible without conducting an evidentiary hearing. Respectfully submitted. Yeah, for me, personally, I would love a Daubert hearing. I really would, but that's purely for my own satisfaction of later reading the transcript from that Daubert hearing where Dr. Baden annihilates the defense arguments. That this is the sole reason. If the judge says, no, we don't need a Daubert hearing, I'm fine. I'm fine with that. I really am. I promise you, I really am. So that was this. And let's just say, yeah, there are more. There are so many more. You have this one regarding search warrants, which was the one I was planning on reading. You have this one, opposition to defendant's request to exclude or limit expert testimony concerning grooming. Okay? You have this one. Government's response to defendants rule 702 motion in limine to exclude the expert testimony. No, that we already. Well, oh, this one. I did check. Government's response to defense motion in limine to exclude argument or testimony drawing improper conclusions from complex DNA mixture evidence. So you see, folks. Oh, there's a whole lot of it. There's a whole lot of documents to go through, but I don't have time for that today because it's in the middle of the night here. And the only reason why I did a live show was because of the motion I just read to you. Now, if I get back from work at a good time tomorrow, I will start a lot earlier. I will try to start around 6 p.m. my time, which is noon Eastern time. And then we will go through a few of these government opposition or to defendants' motions in limine regarding different subjects. So that is for tomorrow. The Sandra Birchmore case is ramping up. They are approaching trial. And in my opinion, the evidence is very, very strong. But had the state charged Matthew Farwell, it would have been a more straightforward way. Because in the federal charge, they have to prove beyond reasonable doubt that Matthew Farwell ended her life because she was about to expose him for what he is. That is not needed in state court. So, folks, thank you for showing up at this unusual hour for my streams. And yeah, I will see you all back here tomorrow for a whole lot more regarding the Sandra Birchmore case. A whole lot more. Now let's see here. According to Rumble, in order for me to keep my status as a Rumble content creator program, whatever's, I have to raid someone at least 5 times during a month, and I have no clue who to send you over to. This looks like someone. Let's see here. How do I do that? I have no idea how to do this. Let's see, I think raid. And the old stream URL is what I need. There. I hope this works. I have no clue. Oh, is Shizzy on? Oh. Oh, look at that. Yeah, I will raid Shizzy. I hope this works. There. Confirm raid. There. All right. That is all I had for you. Thank you so much. Thank you for the help. And I will see you all back here tomorrow. You all have a good one. See ya. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for winter laws.